everyone, this is Gitanjali Singh, and in previous video we talked about the powers of the inherent power of the High Court under section 482 of CRPC. Now in this video we will determine the test under which High Court can quash any or prevent any abuse of powers, the landmark cases and the following principles that has been laid down in the cases. Now to determine whether there has been any abuse of court or is to see whether a bare statement of facts of a case would be sufficient to convince the High Court if it is fit case to get interfered by the High Court at intermediate state or not, whether in the admitted circumstances it would be a mock trial if the case is allowed to proceed. Now the reasons where the High Court can interfere are long lapse of time, failure or impossibility to supply to the accused, and whether the other relevant documents are available for it. These are the grounds of High Court to quash the proceedings against the accused. Now to secure the ends of the justice and prevent the abuse of power by subordinate courts, many judgments came and gave the following principles where High Court can interfere between the trials or not. Now, High Court has no power to review its own order under section 482 of CRPC. Court cannot alter or review its judgment or final order after it is signed except to correct the clerical or arithmetical error. As soon as the judgment is pronounced or order is made by High Court, it becomes functus officio, that is ceased to have control over the case and has no power to review, override, alter or interfere with it. Power of review is not an inherent power and must be conferred on a court by a specific or express provision of that effect. Now in the following case of landmark judgment of State of Haryana versus Bhajanlal in 1992, a two-judge bench of the Supreme Court of India considered in detail that the provision of section 482 and the power of High Court to quash criminal proceedings or FIR, whether the allegation made in the FIR or the complaint, even if they are taken into action at their face value and accepted in their entirety, do not prima facie constitute any offence or make out a case against the accused. Whether the allegation is FIR or other materials, if any, accompanying the FIR do not disclose a cognizable offence justifying an investigation by police officers under section 156(1) subclause of the court, except under an order by a magistrate within the purview of section 155 subclause 2 of this code. Whether the allegation made in the FIR or complaint and the evidence collected in support of the same do not disclose the commission of any offence and make out the case against the accused, or where the allegation in the FIR do not constitute a cognizable offence but constitute only a non-cognizable offence. Many other principles were given, but even though the inherent jurisdiction of High Court under section 482 is very wide, it has to be exercised frankly and carefully with the caution and only when exercise is justified by the test specifically laid down in the section itself. In the state of Bihar versus KJD Singh, the Honorable Supreme Court had a question whether the criminal proceedings can be quashed even before the commencement of the trial or not. The Supreme Court went ahead and held that the inherent power under section 482 has to be exercised for the ends of the justice and should not be arbitrarily exercised to cut short the normal process of criminal trial. After the review of Catena of authorities, Pen DNJ in Janata Dal versus H.S. Chaudhary has deprecated the practice of staying criminal trials and police investigation except in exceptional cases, and present case is certainly not one of the exceptional cases. In the famous case of R.P. Kapoor versus State of Punjab, Honorable Supreme Court went on to the limit to the powers of Honorable High Court within the ambit of CRPC. It was held that inherent power of High Court cannot be invoked in regard to matter which are directly covered by specific provisions of CRPC. It is well settled that inherent power under Section 482 can be exercised only when no other remedy is available and to procure the prevent injustice and abuse of the courts by subordinate courts to the litigant and not where specific remedies provided by the statute. If an effective alternate remedy is available, the High Court will not exercise its power under this section, especially when the applicant may not have availed of that remedy. Whether or not a remedy is present, the High Court does not have the power to interfere with the proceedings, and if an applicant does not exercise its remedy of that problem, then also High Court cannot interfere between the proceedings of that. Now, to conclude this topic, Section 482 of CRPC is widely and the scope, and it is essential for the functioning of high courts in order to meet the end of the justice, but at the same time it must be noted that it must not be misinterpreted, and it is so vast that it can be assigned to different cases but to meet the end of the justice itself. So it becomes more important for the courts to use it wisely and according to the guidelines laid down by High Court precedents and the Supreme Courts. Section 482 in its current form has seen several changes with the changing time and as per the requirement in any situation. The guidelines framed by the Supreme Court in several of its judgments have played a key role in constraining and limiting the ambit and scope of inherent powers of the High Court, and to ensure that it is not being abused by law practitioners. Section 482 of CRPC has made its space in CRPC in order not only to enable the High Courts to provide proper justice but to curb the filling and fictitious complaints. That's all. Thank you.